In this lesson, we'll go over the Georgia Fair Lending Act, GFLA. GFLA was enacted with the intent to protect the borrowers of subprime loans, loans with higher than market interest rates, from predatory lending practices. Because these borrowers typically do not qualify for a conventional mortgage loan, lenders often charge excessive fees and exorbitant rates. The GFLA was passed in an attempt to curtail such practices. Let's start with Section 7-6A-3, which covers limitations of home loans. In the state of Georgia, home loans are subject to certain limitations and prohibited practices. These include the following. 1. A creditor may not make a home loan that finances, directly or indirectly, the following: any credit life, credit accident, credit health, credit personal property, or credit loss of income insurance, debt suspension coverage, or debt cancellation coverage. Any life, accident, health, or loss of income insurance without regard to the identity of the ultimate beneficiary of such insurance. 2. If the borrower is in the process of refinancing an existing loan, a creditor or servicer may not recommend or encourage default on the loan prior to and in connection with the closing or planned closing of the refinance. 3. A creditor or servicer may not charge a borrower a late payment charge unless the loan documents specifically authorize the charge, and the charge is not imposed unless the payment is past due for 10 days or more, and the charge does not exceed 5% of the amount of the late payment. 4. A late payment charge may not be imposed more than once for the same late payment. 5. If a late payment charge is deducted from a payment made on the home loan, and such deduction results in a subsequent default on a subsequent payment, no late payment charge may be imposed for such default. 6. A lender may apply any payment made in the order of maturity to a prior period's payment due, even if the result is late payment charges accruing on subsequent payments due. And 7. A creditor or servicer may not charge a fee for providing the balance due to pay off a home loan or to provide a release upon prepayment, except if the information is provided by facsimile or within 60 days of a previous request. A processing fee of up to $10 may be charged. Payoff balances must be provided within 5 business days after the request. Next, let's go over Section 7-6A-4, which covers flipping a home loan. Knowingly or intentionally flipping a home loan is not allowed. Flipping a home loan involves a borrower refinancing a home loan that is less than 5 years old when there appears to be no reasonable, tangible net benefit to the borrower considering all of the circumstances, including, but not limited to, the terms of both the new and refinance loans, the cost of the new loan, and the borrower's circumstances. A refinancing transaction shall be presumed to be a flipping if a high-cost home loan refinances an existing home loan that was consummated within the prior 5 years, and the original mortgage was originated, subsidized, or guaranteed by a government or a nonprofit organization, and the original loan bears a below-market interest rate or has non-standard payment terms beneficial to the borrower, such as payments that vary with income, are limited to a percentage of income, or where no payments are required under specified conditions, and as a result of the refinancing, the borrower will lose one or more of the benefits of the special mortgage. It is important to note that refinancing transactions mortgage loans originated by, purchased by, or assigned to the Georgia Housing and Finance Authority shall not be presumed to be a flipping. In any action instituted by a borrower alleging a violation of this code section, the borrower shall only be entitled to costs and attorney's fees if the presiding judge allows them after determining that the defendant willfully engaged in the act or practice and there was unwarranted refusal by the defendant to fully resolve the matter. Next, we'll cover Section 7-6A-5, which discussed limitations of high-cost home loans. High-cost home loans shall be subject to the following limitations and prohibited practices. 1. No prepayment fees or penalties shall be provided for in the loan documents for a high-cost home loan, or charge the borrower after the last day of the 24th month following the loan closing. 2. A high-cost home loan shall not contain a scheduled payment that is more than twice as large as the average of earlier scheduled payments, unless it is adjusted to the seasonal or irregular income of the borrower. Include payment terms under which the outstanding principal balance will increase at any time over the course of the loan because the regular periodic payments do not cover the full amount of the interest due. Contain a provision that increases the interest rate after default unless it is a variable rate loan and the change is not triggered by the default or the acceleration of the indebtedness. Include terms under which more than 2 periodic payments required under the loan are consolidated and paid in advance from the loan proceeds provided to the borrower. 3. A provision of a high-cost home loan agreement requiring a borrower to assert any claim or defense in a forum that is less convenient, more costly, or more dilatory for the resolution of a dispute than a judicial forum established in this state, or that limits in any way any claim or defense the borrower may have is unconscionable and void. 4. A creditor shall not make a high-cost home loan without first receiving certification from a counselor with a third-party nonprofit organization approved by the United States Department of Housing and Urban Development or the Georgia Housing and Finance Authority that the borrower has received counseling on the advisability of the loan transaction. And, unless a reasonable creditor would believe at the time the loan is consummated that the borrower will be able to make the scheduled payments based upon current and expected income, current obligations, employment status, and other financial resources other than the borrower's equity in the collateral that secures repayment of the loan. 5. A creditor or servicer shall not pay a contractor under a home improvement contract from the proceeds of a high-cost home loan unless they satisfy a few exceptions. 6. A creditor or servicer shall not charge a borrower any fees or other charges to modify, renew, extend, or amend a high-cost home loan, or to defer any payment due under the terms of a high-cost home loan. 7. Before initiating foreclosure proceedings, a creditor shall provide written notice of the intent to foreclose to the borrower sent by certified mail, return receipt requested, to the borrower's last known address at least 14 days prior to the publication of the required legal advertisement. 8. If a high-cost home loan is accelerated and demand made for payment in full of all sums secured by the security instrument, the borrower or borrower's agent has the right to cure the default at any time up to the time title is transferred by means of foreclosure, by judicial proceeding and sale, or otherwise. 9. The borrower shall not be liable for any attorney's fees relating to the borrower's default that are incurred by the creditor or servicer prior to the time the creditor or servicer files a foreclosure action or takes other action to seize or transfer ownership of the home. 10. After the creditor or servicer files a foreclosure action or takes other action to seize or transfer ownership of the home, the borrower shall only be liable for attorney's fees that are reasonable, actually incurred, based on a reasonable hourly rate and a number of hours plus any other reasonable and necessary expenses. 11. If a default is cured prior to the initiation of any action to foreclose or to seize or transfer a home, the creditor or servicer shall not institute the foreclosure proceeding or other action for that default. 12. If a default is cured after the initiation of any action to foreclose, the creditor or servicer shall take such steps as are necessary to terminate the foreclosure proceeding or other action. 13. Prior to initiating foreclosure or other action to seize or transfer ownership of a home, a notice of the right to cure the default must be delivered to the borrower, informing the borrower of the following. 1. The nature of the alleged default and of the borrower's right to cure the default by paying the sum of money required. If the amount necessary to cure the default will change during the 30-day period after the effective date of the notice due to the application of a daily interest rate or the addition of late fees as allowed by this chapter, the notice shall give sufficient information to enable the borrower to calculate the amount at any point during the 30-day period. And 2. The deadline for curing the default to avoid acceleration and initiation of foreclosure or other action to seize the home, and the name, address, and phone number of a person to whom the payment shall be made. The deadline must be at least 30 days from the effective date of the notice. And 3. If the default is not cured by the deadline, steps may be taken to terminate the borrower's ownership in the property by commencing a foreclosure proceeding or other action to seize the home. And 4. The name and address of the creditor or servicer and the telephone number of a representative whom the borrower may contact if the borrower disagrees with the claim of default or the calculation of the amount required to cure the default. 14. A provision in a high-cost home loan that permits a creditor or servicer, in its sole discretion, to accelerate the indebtedness will not be enforced. 15. All high-cost home loan documents that create a debt or pledge property as collateral shall contain the following notice on the first page in a conspicuous manner. Notice: this is a mortgage subject to special rules under the Georgia Fair Lending Act. Purchasers or assignees of this mortgage may be liable for all claims and defenses by the borrower with respect to the mortgage. Next, we'll cover Section 7-6A-6. If a home loan was made, arranged, or assigned by a person selling home improvements to the dwelling of a borrower, the borrower may assert against the creditor all affirmative claims and any defenses that the borrower may have against the seller or home improvement contractor. Except, this shall not apply to loans other than high-cost home loans, unless applicable law requires a certificate of occupancy, inspection, or completion to be obtained, and said certificate is not obtained. Anyone who purchases, is assigned, or otherwise becomes a holder of a high-cost home loan shall be subject to all affirmative claims and any defenses that the borrower could assert against the creditor, unless the purchaser or holder demonstrates, by a preponderance of the evidence, that the purchaser or holder exercised reasonable due diligence at the time of purchase or within a reasonable time thereafter, intended to prevent the purchase or assignment of high-cost home loans. The relief granted to a borrower of a high-cost home loan under this section may be asserted by the borrower only in an individual action, shall not exceed the sum of the amount of all remaining indebtedness of the borrower under such loan, and reasonable attorney's fees in such individual action, and may be sought by the borrower after notice of acceleration or foreclosure of the loan, asserting a violation of Code Section 7-6A-4 or 7-6A-5 in an individual action to enjoin foreclosure or to preserve or obtain possession of the home secured by the loan, and must be bought within 1 year from the date of the occurrence of the violation. It shall be a violation to attempt in bad faith to avoid the rules of the Georgia Fair Lending Act by dividing any loan transaction into separate parts or structuring a home loan transaction as an open-end loan for the purpose of evading the provisions of the GFLA, when the loan would have been a high-cost home loan had it been structured as a closed-end loan. Engaging in any other subterfuge with the intent of evading the GFLA is also a violation. Next, we'll cover Section 7-6A-7. Any creditor found by a preponderance of the evidence to have violated the Georgia Fair Lending Act shall be liable to the borrower for the following: actual damages, including consequential and incidental damages, and statutory damages equal to the recovery of 2 times the interest paid under the loan, and punitive damages, and costs and reasonable attorney's fees. A high-cost home loan borrower may be granted injunctive, declaratory, or other such equitable relief as the court deems appropriate in an action to enforce compliance with the GFLA. Finally, we'll cover Section 7-6A-9. A creditor, servicer, or insurer providing insurance through premiums financed by a creditor of a home loan who, when acting in good faith, fails to comply with the provisions of the GFLA will not be deemed to be in violation of the GFLA if the creditor, servicer, or insurer establishes that either within 90 days of the loan closing and prior to receiving any notice from the borrower of the compliance failure, the creditor or servicer has offered appropriate restitution to the borrower and appropriate adjustments are made to the loan, or within 90 days of discovering a compliance failure and prior to receiving any notice of the compliance failure, and the compliance failure was not intentional and resulted from a bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid such errors. The borrower is notified of the compliance failure, and appropriate restitution is offered to the borrower, and appropriate adjustments are made to the loan. Examples of a bona fide error include clerical, calculation, computer malfunction and programming, and printing errors. An error of legal judgment with respect to a person's obligations under this chapter is not a bona fide error.